Good evening, everyone. Good evening, guys. Can you guys hear me?
Yes, we can hear you.
Yeah, all right. Good evening. Welcome to our first class for the IP section. This is the fourth quarter for 2023. We've had 4 quarters. We have 3 previous quarters, first quarter, second quarter, third quarter, and this is the final quarter of the year. This is our first week for the quarter. This is our first week for this quarter, and our topic for this week is IP for business. Okay, before we go to what we have for today, I would like to take the following announcements. All right. Okay, so registration is still ongoing, right? Registration is still ongoing. If you have friends and family that still want to register for the course but feel like time has gone, we are just trying to let you guys know that registration is still ongoing up to the second week. I think during the onboarding session, we made it clear that registration will be ongoing till the second week. So the courses that are available, we have intellectual property, what we are having now. We have artificial intelligence and technology. We have the energy industry. We have fintech industry, health tech and law, patents drafting. We are not currently doing patent drafting this quarter, but subsequently in the next quarter we'll be doing that. Same with blockchain, NFT, and metaverse. But data privacy and protection, something we are currently on data privacy and we're also offering data privacy and protection and entertainment business and law. All right. There'll be an opportunity to have a 30 minutes one-on-one section with your favorite mentor. You can reach out to us for us to give you the details of your favorite mentor. Give you the opportunity to have a one-on-one, give you an opportunity to have a one-on-one section with your favorite mentor. What you will get from that section is get hacks, secrets, life lessons, directions from your favorite mentor. You can follow the link or reach out to us, and then we'll guide you on how to go about that. So before that, okay, today we'll be going to our mentors for the section. Our first mentor for today, we have Regina Onwumere. Sorry for the pronunciation. We have Miss Regina Onwumere. Regina is a senior associate in Aluko and Oyebode, and Regina is a senior associate in Aluko and Oyebode, and she has a robust experience in IP prosecution and related practices. Garnered for years, Regina is a Harvard alumni, and she graduated from the University of Nigeria, Nsukka, with an LLB honors in 2012 and the Nigerian Law School in 2013. Regina was recently nominated to serve in the International Trademark Association INTA committee for the 2022-2023 term. In addition to being selected as an outstanding trademark and patents practitioner in the WIPR Leaders Guide 2021, Regina is extremely passionate about intellectual property law and policy and how IP affects clients' business. Our second mentor is Ms. Amele Tala-Foda. Amele Tala-Foda is an intellectual property strategist and an experienced trademark negotiator. She provides assistance and guidance to clients on intellectual property. Through her technical skills, she supports her clients from the beginning of their projects and during the whole life cycle of their intellectual property rights. She is a deputy director of cabinets C&F and an observer at MNOAPI, Associates of Legal IP Attorney of Cameroon. and the co-editor of the intellectual property news flash titled T&F IP Spotlight. Okay, and our last mentor for today is Christiana Yeside Yonji. Christiana Yeside Yonji is a legal practitioner specializing in corporate/commercial and IP law. She has partaken in professional training at the World Intellectual Property Organization. She is highly skilled in providing advice and counseling to clients who are in sectors where IP is fundamental to business strategies. Sorry. Okay. With that being said, okay, I can see Miss Amela. Please, can we welcome our first mentor for today, Miss Amela Tala Folder. Please, ma, you're welcome to JIIPCC Mentorship Program. Our topic for today is IP for business. Please, ma, if you are here on screen with us, please, ma, can you go ahead and give us what you have for today?
Okay, good afternoon, everyone. My name is Amel Talafuda. I'm the managing partner of Cabinet T&F. I'm a certified IP counsel from of OAP region, and it is a pleasure for me to be here today. So I was assigned to talk about IP and business. And I went through the different presentations. So I have a particular structure to deliver mentorship. I often do it through a case study. So I went through the different presentation, and there are some aspects that are good and other that are not really stretch point. The first thing that I have to underline is that IP and business cover many different aspects, and we have to take in consideration that if we talk about IP and business, it means that we are talking about IP protection, we can talk about IP enforcement, IP commercialization, IP contract, IP valuation, IP audit, and so on. So since it's too large to talk about IP and business, and the time that is allowed to our presentation is really small, what we are going to do is to work based on a case study so that we can enlighten few main points of IP management in order for each of us to understand, to have an overview of intellectual property, let's say that, because it will not be focused on IP management. You can have few definition of what is intellectual property, what are the different IP assets, what how can I explain it? How do we have to proceed in order to take the better advantage from our intellectual property? What are the different tips that are interesting to know when it comes to manage your IP asset? So I've just shared a small case study. I don't know if Dennis can check the email and share the case study with the different attendees in order for them to read into the same time with me and to be able to better understand. Dennis, are you there?
Smart. I will go check it, Smart. Thank you. Thank you for that.
Okay. So the idea is to go through the case study in order to identify the different mistakes that, take note, first of all, that the case study is not a true case study. I wrote a case study according to the bullet point that I wanted to underline during our session. So have you already shared it, please? Can we go ahead? You can even put it on the screen if it is possible.
All right, I'll do that now. Come in. Okay. Our case study. This is our case study for today.
Okay. So the case study is about Ariel. Ariel is a brand innovator, owner of a company X. Okay. Is it okay? Can I go ahead?
Yes, you can go on.
Okay. Because on my side, I think that I'm not able to read everything. Maybe you have to go on in two steps so that people can read easily.
Okay.
Or you can even choose to share it directly as a message to each of the attendees.
Oh, all right, Ma. Let me do that.
Yes, please.
Okay. It's on the chat box.
Okay. So we were saying that Ariel, the case study of the day is about Ariel. Ariel is a brand innovator who is also an owner of a company called Company X. He works with two collaborators and often hire external consultants who are assigned to support his project with their technology. It means that Ariel doesn't have all the technology in order to work on his innovation. So he has recently found that there are many families in the north of Nigeria who doesn't have access to light. He thus decided to work on a solar panel project based on recycled fiber of plant roots, in order to ensure that the population of this region should have access to light as everywhere. He works on this project with one of the two collaborators and one external consultant. When it came time to him to look for funds, he chose to present the said project to different investors but without signing NDA. That is the first mistake. One of these investors was interested by the project, but when he asked for proof of IP ownership, he discovered that Ariel was not having any proof. He didn't succeed to convince this investor, but finally chose to protect his solar panel. He thus went to Nigerian Office of Intellectual Property and applied this time for industrial design application. He supposed that it was the right time for him to enter into the market. He does manufacture 1,000 solar panels and has started selling them. One of his collaborators who were aware of the importance of IP take the service of a professional IP counsel and apply for patent and trademark. He also did a notary act of a laboratory book. When Ariel has discovered it, he became angry and chose to see an IP professional now in order to see what are the different options that he can take in order to solve this problem. So the idea here is to analyze this case study, to make the different observation, and to give proper recommendation to Ariel and also to the different collaborators. The following aspects should be at the center of your analysis: identification of IP assets. That's the first job. The different mistakes, we have to underline the mistake made by Ariel, the mistakes made by Ariel collaborator, the good practice when it comes to manage such projects, and the option offered to Ariel in order to choose to see how not to lose his complete investment. So when we take the first question, in terms of IP assets, intellectual property refers to any creation of the mind that can be protected by trademark, by patent, by industrial design, and also by copyright. So trademark, I'm sure that most of you know the definition of trademark. Trademark is any sign that can be fixed on a product or that can be associated to particular service. Myself, my company is Cabinetier&F, and I've already registered the brand. The idea here is to ensure that when you register your brand, you can have a monopoly to use it into a particular market for particular product or services. Relative to patent, we can say that patent is the certificate which is given to somebody who work on an innovation. He bring a solution to a particular technical problem into a market. So he has this patent, and through the patent, he has a monopoly to use it, to commercialize it, and to authorize any other person to do the same or not. Copyrights refer to any original creation of the mind, when design refer to the appearance of products. So these are the different IP assets on which we will focus today, because there are many other IP assets, but who are less important for us during our training. We also have trade secrets, who is not a registered IP asset. We also have what we call geographical indication and so on. So this was the first point. The next question that we ask here is to know the different mistakes that Ariel made. I don't know if some of you are a bit aware on intellectual property. If yes, can they give me their own appreciation of the mistake? I just want 2 persons, maximum of 2 persons, who can give the different mistakes that Ariel did while using the intellectual property assets. Is there anyone?
Okay.
So then
can I just pitch in?
Go ahead, Zainab.
Okay, when he realized that he needed to get an intellectual property to work on his solar panel, instead of him to get to like a professional who will give him advice on the kind of intellectual property that he should get, he discarded the idea and went directly to the office and got the wrong one.
You are right. Yes, that is the main problem, because there are many people who think that having intellectual property is just something, IP asset is just something that you choose like that. There are some clients who often come and say that, okay, Mrs. Stella, I just want to register my brand. But people have to take in consideration that intellectual property starts with a strategy. You have to have a particular strategy, and this strategy helps you to understand what are the stakes of intellectual property into your business or around your innovation. You cannot have a solar panel and directly think about a design. because the industrial design covers the appearance of your product. It's true that this solar panel can have a particular appearance. That is true. But this one is not the main IP asset of the innovation, because here the main IP asset will be the patent and also trademark. Patent because he used a particular process in order to ensure that we can have light using the recycled fiber of plants. Okay. And trademark because he cannot sell solar panel without a brand. So this one was the most important one, even if he can add other things. Like somewhere we read that the collaborator did what we call a book that describe a laboratory book that describe how you work on your intellectual property, because normally it is advised to people, especially those who work on things like patents or those who work on innovation that are not protectable through industrial design assets, I mean patent, trademark, and industrial design, to have a laboratory book in order for the judge to observe and understand that maybe this guy took 1 year, 2 year, 3 year or more to work on this project. The day one, he worked on this aspect, he finished to describe it into the laboratory book. The day two, he did this other thing, day four, and so on. So this one is a proof that can also consolidate your defense when it comes to defend your intellectual property right if you are facing litigation. So this one is one of the mistakes that he did. But when we take time to read the text, we also observe that he was discussing with investor without having NDA. This one is also a huge mistake, because people feel that we can discuss on our project with everyone without taking any security approach. Because when you work with your collaborator, when you have to discuss with a partner or an investor, you have to know that through your discussion, you will always give him or her one or two things that can be a key aspect of your project. And this key aspect, even if it is a trade secret, it's not good to share it like that. You have to ensure that this person should close the mouth after your discussion. That is why NDA is always important. It's true that in our context, we agree that people don't really like such things. When you start discussion with somebody and you say that we have to sign an NDA, somehow they meet it as something that is wrong. I don't know why, but I think that is just a wrong perception that people have. But the owner of the innovation does have to make everything in order to try to convince the other part to sign an NDA. If it is not possible, it means that during the discussion, the guy has to ensure that he will not give too much information. But this one is really difficult, because if you want to convince somebody, normally you have to use all the tools that you have on your position in order to ensure that you can convince the person to work with you. Or on the other side, you can choose to protect your intellectual property asset before starting any collaboration or discussion with somebody. So this one is the second problem. The next one, I think that the guy worked with the employee without signing anything with the employee. It's true that you pay somebody to do a particular job. Either it is a consultant or an internal employee. But paying that person doesn't mean that that person doesn't have IP rights. I mean, the what we call how do you call it in English? Excuse me, since I'm so fresh, because from time to time I forgot few words. The moral right. Okay, it comes. The moral right, because the moral right make that it's something that you cannot disconnect to the person who work on the innovation. So for that purpose, it is always advisable when you work with somebody to ensure that into the agreement of the employee, or if you have somebody who is just an intern into your company, to put 1 or 2 lines regarding the fact that the guy is giving you an assignment to use the said intellectual property. So if you don't do that, and the IP attorney of your collaborator knows intellectual property well, he can demonstrate that maybe the amount that you are giving to the guy, it is not sufficient, that you have to give him more. But if you have few lines that specify that the guy, I assign you all the intellectual property right, now you don't have any problem. And if you have a litigation with the guy, you can have proof to demonstrate that the guy is not, he is into the bad faith. He just wants to use your knowledge or your reputation to make his own business. So that is another point. The next one, when we follow up the case study, we see that the guy, while discussing with the investor, he was not aware on the fact that one aspect that is really important when it comes to negotiate funds with an investor is the aspect of ownership of intellectual property. Because somebody cannot decide to invest money, enough money on a business without knowing who is really the owner of this business or of the innovation. It means that the investor here wanted to be sure that the guy who is presenting the solar panel is really the one who owns the invention. So if we were having a certificate of patent or a patent application, he can say that he is still proceeding, but I apply for it because I'm the one who worked on it during 1 or 2 years. So the investor chose not to follow up the discussion with him because of this aspect. So I think that, if I'm not wrong, these are the main problem that the mistake that the guy did during the negotiation of the development of his own business. The last one, but not the least, we have to take note that intellectual property intervenes into the different stage of development of any innovation. So if I was Ariel, normally I should have been able to identify that at the beginning, I'm still writing the process, the development process of the solar panel. I have to note it somewhere into my laboratory book. After that, when I start negotiating, I have to remind that now I have to ensure that I have IP right into the region where I'm interested to develop my business. After that, maybe I can launch the project. I've already registered the IP right, but I know that maybe I receive 2 or 4 points of view from the consumer, and the consumer was saying that this product, maybe you have to perform 1 or 2 aspects. It means that I have to go back to the R&D section in order to see how to improve the product. And when I improve the product, I have to do the corresponding process. And we have to take in consideration that IP has a duration. IP had length for the different period. Either it is a trademark, who is for 10 years, renewable indefinitely, a patent, who is 20 years, design, who here is in Cameroon is 5 years, renewable 3 times. But in different countries, it can go up to 25 years. And copyright, who starts from the death of the owner of the original creation till 50 years after he died in Cameroon, but I think that in Nigeria it's 70 years. So all these aspects has to be taken in consideration in order to ensure that at the end of the course, when you start negotiating, when you start IP commercialization, if you choose a particular process to commercialize your IP, you already have the basics, and the basics is protection. The basics are contracts in order to ensure that now you can follow the next steps without having any fear. So I don't know if at this level we have few questions. If not, I will just continue with the next question. Hello.
Ma, we want to give opportunities to the other mentors to also have their section. Then towards the end, there will be a question and answer section, so that
Okay.
any question that arises as a result of the section itself, including yours,
Okay.
will be asked, and you can address that, ma.
Okay, so I think that's all. Maybe we will answer to the other question at the end of the session. Thank you. I cannot get you.
I say thank you for that wonderful section. We'll be calling on our next mentor, Miss Regina Onwumere. Sorry again for the way I pronounced your name. Sorry about that. Please, if Miss Onwumere is available, please, you can go ahead with your section, ma.
Hi, Dennis. I'm here. Good evening, everyone.
Good evening, ma. Welcome.
Thank you very much. And thank you, Talal. I think that she has basically covered everything, but just to highlight a few points. Today we are discussing intellectual property for business. That is IP for business. And I believe that we all know what the business is, and that we have a broad view of what intellectual property is. It is a creation of the human intellect. And I also believe that at this stage, we understand the different categories of intellectual property, which are trademark, copyright, patents, industrial design. Am I audible, please?
Yes, you are, ma.
Okay. Industrial design, trade secrets. There are geographical indications and the others. So just to add that businesses are to be very proactive and not reactive in protecting their IP rights, because these IP rights are assets, they are valued. They have both monetary and economic value. It is true that IP is not tangible, but the value that we get from intellectual property is tangible. I don't know if you want me to go into the meaning of trademark, the processes. I think that Salah had covered all that. Would that be necessary?
You can just go ahead with anything you're comfortable with, ma.
Okay, so trademark, as we already know, can be a word like apple, as we know, and a phrase like there's a popular phrase by Nike, just do it. It's a phrase that is trademarked. It can be a symbol, a design, and it can be a combination of all these. And one aspect of a trademark is that it is used to distinguish those services of one company from the other. And in some jurisdictions, unlike Nigeria, they are able to trademark things like sound, smell, moving objects. But the Nigerian Trademarks Act does not, as of today, recognize these forms of trademark. And then quickly we move to copyright, simply the right to copy. Copyright protects pictures, videos, blogs, music, software programs, and so on and so forth. I believe that by now we already know that in 2022, the immediate last president signed the Copyright Act.
Sorry, we lost you.
Yeah, apologies. So on the 17th of March, 2023, the immediate last president, that is President Muhammadu Buhari, signed into law the Copyright Act 2022, which repealed the Copyright Act of 1988 as amended. And this was to bring to reality, particularly copyright protection in the digital space. Then quickly on to patents. Patents, as we know, confers on the patentee the right to preclude others from taking certain steps, such as importing, selling, using, stocking, or applying the process, the patented process. So according to a WIPO resource, it's defined a patent as a document issued upon application by a government office or regional office acting for several countries. We know that there are regional offices like the JIIPCC, the OAP, the EUIPU, and the others, which describes an invention and creates a legal situation in which the patented invention can normally only be exploited. And by exploitation here, we mean used, manufactured, imported, or sold with the authorization of the patent owner. And from this definition, we see that a patent is granted by a government. And it must be an independent government like Nigeria, like the USA. And if it's regional, we have the JIIPCC and the OAP, and it grants exclusive right to exploit the invention. So patent is not like copyright that is automatic. There has to be an application which is reviewed, examined before a grant is issued by the government. And so in Nigeria, there are specific requirements for patentability. The item or the invention must be new. And by newness here, the Act says that it must not form part of the state of the art. There must be an inventive activity, meaning that there must be something, there must be an addition to what's already in existence. And the invention must be capable of industrial application. And there's what we call improvement patents, because as we know it, as someone said that there's nothing new under the sun. There's really and truly, there's nothing new. So improvement patent is a patent that improves on what is already in existence. So most of the patents that we see in recent years are improvements on what had been in existence before now. So, and also in Nigeria, according to the Patents Act, and this is applicable in many other jurisdictions, there are some inventions that are not patentable, but specifically in Nigeria, plant and animal varieties are not patentable, and principles and discoveries of scientific nature are not patentable, and inventions that to be contrary to public order or morality, they are not patentable. So if these kinds of patents applications for this kind of patents are submitted at the patent office in Nigeria, they will be rejected. And for the procedure for patent grants in Nigeria, application is made to the patent office. There's an application form, there's a standard application form, and if you're filing through the online platform, you just fill the form, providing the name of the inventor, the title of the patent. There's an abstract. An abstract is a summary of the patent. And then these are, so the statutory documents, the specification, the drawing, and the claim. And in a patent application, your claim seems to be the most important document, because that is what is granted to the patentee, the inventor. So the claim is usually carefully drafted. And quickly to industrial design. As we know, industrial design protects the aesthetic parts of the products. That is the attractive aspects of the products. Similar procedure as we have in patents, but in industrial design, if you're filing through the online portal, provide the name of the applicant, the creator. In patent, we call it the inventor, but in industrial design, it is the creator of the design, the title, and then the design, the picture of the design or a graphic representation of the design is also uploaded, and then it is examined. If it's accepted, an acceptance notice is issued. It could be queried, the registry could query the application, and you'll be requested to provide certain further information for further examination. In Nigeria, examination of patent and industrial design is as to form. There's no substantial examination yet. So if the documents are in order, your patent will be granted or your industrial design will be registered, and the certificates would be issued to the applicant. And I talked about trade secrets. Trade secrets consist of formulas and processes or any other information that is of economic value to a business. And I believe we know about the geographical indication. These are signs. They are more like trademark, but the basic difference is that the geographical indications, they qualify particular kinds of products produced in a particular jurisdiction. They are used to identify. So for instance, we have champagne, we have Ijebu Gari for Nigeria, we have the Ofada rice also for Nigeria. So in conclusion, I would say that businesses are to be intentional about their intellectual property rights and taking proactive measure to protect their IP rights from the get-go, because these IP rights are of tangible value. There are enormous value attached to them. Thank you very much.
Thank you, Ms. Regina. Thank you for that section. Lastly, we'll go to our last mentor for today, Ms. Christiana Longi. Please, Ma, if you can hear us, the stage is yours, Ma.
Thank you very much. Just to correct you, my name is Christiana Longe, not Longi.
Sorry about that.
Okay, thank you very much. So it's nice being here, being part of you today. And Tala and Regina have really done justice to all the topics on IP for business. And Regina talked extensively on patents, and I really loved, the issues she raised, and she talked about the criteria for patents and how patent is being, things that are contained, how patent is being drafted. So I'll just talk briefly on the requirements for trademark registration. in Nigeria. So a trademark, as has been said, is any sign or any combination of signs that is used to distinguish the goods and or services offered by one undertaking from those offered by another. And the characteristics for trademark is that for a trademark to be registered is that it must be distinctive and it should not be deceptive. And then it must also comply with other protection requirements established by the law. It must not mislead or be contrary to public order. The requirement for trademark registration in Nigeria is the applicant's details, the details of the trademark, what you want to register, the details. That's the name. If it's a name, the name, or if it's a logo, the logo. Then that's the details. If the business the person is doing, then representation of the mark as well. That's if it's a name, the name. If it's a logo, the logo. Then the classification of goods and or services. Nigeria, we use the NICE classification of goods and services. We have about 45 or thereabouts of those NICE classifications. So you can, go and read more about them. And then a signed power of attorney is also a requirement to register a trademark. Then the procedure for registration of trademark is the first thing is that you have to do availability search. The first step is to conduct an availability search at the trademark registry to ensure that there are no marks similar or in conflict with the proposed mark. And the second point here is application. After you must have done the search and the name is available, it's not conflicting with an existing trademark, then you start the application process proper. The application is filed at the trademark registry. After submission of the application form and payment of the necessary fees, immediately the payment has been confirmed, you get your acknowledgements. And for the trademark, it's done online. Trademark registration is done online. So I'm talking about the online registration. So after you must have made the payment and the payment has been confirmed, you get automatically an acknowledgement letter confirming the receipt of your application. And after the registration has been acknowledged, your application has been acknowledged, then the next thing is to wait for your acceptance. When the application is approved on the grounds that the mark is distinctive and is not deceptive, a letter of acceptance will be issued within 1 to 3 months by the registrar of the trademark. This letter of acceptance is also being issued online as well. So it's just for you to log into your portal, be logging in from time to time to see if the acceptance letters has been, issued. And then after the acceptance letter has been issued, then the next step is the publication and certification. Upon the acceptance of the application, the registrar ensures the notice of the application is published in the Nigerian Trademark Journal. So this trademark journal is not online, it's physical. You have to go to the registry or send someone there to help you to search for the name if the name has been published. So you have to keep searching. And I think this is the most challenging aspect of trademark registration, that publication, the publication, because it takes time. For example, the trademark that I've gotten acceptance for since last year, May, it has still not been published. So you have to keep checking until the name has been published. And after this name has been published, and the purpose of this publication is just to notify interested parties who may have objections to the application. So some people might have objections or they might want to oppose it. So it's just for them to, to be aware that, okay, there's a name, and if they have any interest in the name, they should, quickly go and oppose it. And then the opposition period is 2 months from the date of the publication. Where there are no objection or where an objection raised has been upheld, the applicant may proceed to make an application for the issuance of certificate of registration, and then subsequently, a certificate of registration will be issued by the registrar of trademarks. And a trademark, once registered, is valid in Nigeria for an initial period of 7 years in the first instance, and subsequent renewals are valid for 14 years. And I think that's basically okay. And then I also love to talk about the trade secrets. Businesses that have commercially valuable information that must remain confidential can help ensure this happens through non-disclosure agreement and by limiting the number of people who have access to the information. This non-disclosure agreement is just in form of an agreement, and I love to use for example, the Coca-Cola, they have a trade secret. That's the ingredients, the secret ingredients of, the Coca-Cola. Or even, I love to use this example of, KFC chicken. We all know there are chicken everywhere. You can get chicken everywhere. But when you test KFC chicken, you know that, it is different. And, and I think their power there is their intellectual property there is their trade secrets. You cannot just go to the next, to anywhere they are selling chicken and buy a KFC chicken. You have to go to a KFC store or a KFC restaurant and buy a KFC chicken there. So that the trade secrets there, it's the, that chicken, the way the process is being made, is the trade secrets there. And most times this trade secret is in form of a non-disclosure agreement where parties sign to it and, are liable to the agreements. So I think that's just all for me, because Tala and Regina have said almost everything. And so thank you very much. That's all for me.
Okay, thank you very much, Miss Christina. I would like to see our mentees just send reactions appreciating our mentors, telling them thank you for such a wonderful section in less than an hour. We've gotten so much from them. All right, moving on. Right, before we go into the mentees presentation for today, the weather over here is changing and the place is getting dark. So I would just like us to have like a very brief picture time. If you are in a position to, please can you turn on your camera so that we can just have a quick picture. And for our social media channels, please, if you can you just go ahead and turn on your camera so that we can take a picture before moving on. Please, let's do that quickly so that
it's raining here. I can't on my camera. It's dark where I am. I'm sorry.
Okay, no problem. We'll do that quickly. All right. Okay, and that is that for that. Thank you very much for complying. Okay, we'll be going to the presentations for today. We have two groups for their presentations. We have two groups for the IP class. So we would like to call on group one to have their presentation. Group one presenter, if you are ready, please, we are also ready. You have 10 minutes for your presentation. Please go ahead and carry on with your presentation. You can share your screen so that we can see what you are doing. So group one presenter, please, can you go ahead?
Hello, everyone. Hello, everyone. Can you hear me?
Yes, we can.
Okay, please. My name is Enikome Fadirera, and I am the backup presenter for Group 1, and I will be presenting here intellectual property for business. So what are we presenting on? What would encompass what a patent is, a trademark, why businesses and persons need to register patents and trademark, IP franchises, IP licensing, and IP exports. So let me just go straight to the point now. A patent is an IP right granted by the government of a nation to an inventor that gives them the exclusive rights to the invention for up to 20 years in exchange for disclosing the details of the new technology to society for its ultimate benefit. Section 1 of the Nigerian Patents and Design Act outlines the prerequisites for patent eligibility. And for it to be considered valid, a patent must fulfill certain criteria. It must be novel, the product must be of inventive ingenuity, and it must be suitable for practical application. Now, there are various types of patents. There are three major types of patents. utility, design, and plant patents. Utility patents are inventions that are created for useful and crucial purposes, such as creation of washing machine, dishwashers, manufacturing processes, compositions of matter. There is the design patent, which actually looks at the way a particular design or the way a particular product looks like. For example, smartphones and the way they have like some smartphones with cameras, graphic posters, UX designs, etc. Then plant patents, which is usually granted for the creation of asexual reproduction of unique plants. Most of the time, it's usually flowers. Most of the time, it's flowers. Now, why should a patent be registered? Well, it serves as a form of reward to investors, like moral and nominal reward to investors, where they can be recognized for such innovation that they may have created. Then it also helps to promote and protect their innovations, their intellectual property, in other words. Also, it can help them in probably their assignment or sale of that particular intellectual property, licensing. It also protects their patent rights. It serves as a form of good database for inventions in order to promote availability to interested persons for study, for further undertaking, and to create more or better improvements of that particular product. Now, an example of a patent that registered it and gained revenue is Google, who patented their algorithm called PageRank, which became a major part of their success story. Amazon also created their one-click buying process, which boosted their sales exponentially. Now, an example of business that did not register as patent is Kodak, where they invented the GUI, which is used in several devices today, but they did not capitalize on it, they did not register it, and Apple and Microsoft took advantage of that opportunity and majorly capitalized on it. Now, what is a trademark? A trademark can be seen as an intellectual property right granted by a government to an individual, business, or legal entity that creates and uses a distinctive word, name, symbol, or device to distinguish its products or services from those or any other entity in the marketplace. Now, the trade section 67 of the Trademark Act also defines it as a mark used to propose or to be used in relation to goods for the purpose of indicating, or so as to indicate a connection to the course of the trade or the goods of that person's rights, either as a proprietor or as a registered user. In other words, it's just trying to say that it's like a form of wherein a person registers a particular object, design, that has a serious, like has a, that gives him this kind of, that makes it look, that gives him this kind of connection to it. For example, now, Apple, wherein the Apple design serves as a, wherein the Apple design also serves as a form of showing, oh yes, this is actually our company, it's a trademark. Now, why should businesses register their trademark? For legal protection. Registering a trademark provides legal protection against unauthorized use of other similar marks, and it gives exclusive rights to the owner to use the mark in connection with their goods or services. It also serves as a form of brand recognition. It prevents confusion among consumers who may want to use that particular product or a similar product. Then asset valuation, wherein because your design, your product is trademarked, it may actually increase in value. And then for global protection, wherein it can be extended into other companies, giving you protection in international markets. Now, an example of business that and trademark that registered its trademark and get revenue is Coca-Cola and Apple, wherein they are trademarking their logo and the way their symbols, their design is as contributed largely to their global recognition and revenue. Now, an example of business that did not register as trademark and lost revenue is Burger King, which due to a trademark issue in Australia, they had to change themselves to Hungry Jack's, which made them lose potential revenue. Now, IP franchise. This comprises of all intellectual property rights owned by the owner worldwide that have a connection or can be utilized or exploitable in connection to the Sonic brand or offering, selling related goods throughout the world. In this, there are two forms of it. It can be in two ways. Either the franchisor allowing the franchisee to use its IP intellectual property in specific terms, or if the franchisee develops improvements in existing intellectual property, and if it sends it back to the franchisor to use in his business. An example of business that franchises their intellectual property is McDonald's and Starbucks. Intellectual property licensing. This is when someone is authorized by the owner or the IP holder to use the intellectual property while maintaining ownership by granting a license in exchange for something of value, such as monetary or lump sum, or recurrent payments, which are usually called royalties, or even both. It could either be sole, exclusive, or non-exclusive. An example of this can be seen with J.K. Rowling, where she licensed the Harry Potter book to several companies, which were later used for merchandise, movies, and a whole lot more, which generated a lot of revenue. Now, intellectual property export. This can be seen as the transfer of intellectual property rights from one country to another. It involves granting permission to individuals to another country to use, reproduce, distribute, or even modify the protected intellectual property. This can be done through licensing, franchising, several ways. Now, there are different forms of it. This can either be done through licensing, which involves granting permission to a foreign entity to use intellectual property rights in exchange for licensing fees, royalties, or even both. And secondly, franchising, which involves a form of IP export where a company grants the rights to operate a business using its brand trademark, wherein the franchisor provides ongoing support and receives a percentage of the franchisee's profits. Now, assignment of sale, this involves the transfer of ownership of that particular right to a foreign entity in exchange for a lump sum or other financial consideration, where the buyer becomes the sole owner of the IP and can export it as he desires. Then joint ventures, which involves the collaboration with a foreign partner to combine resources, knowledge, and intellectual property for mutual benefits. It can also include patents, trademark, copyrights, and trade secrets to create a new product or enter new markets. Then opportunities that are associated with intellectual property export. Those are like the advantages. There are three main advantages which were highlighted here. The first one is economic growth, wherein intellectual property exports can contribute to economic growth by generating revenue and creating jobs. Then secondly, market expansion, wherein it's exporting intellectual property allows companies to tap into new markets beyond the borders, beyond their domestic borders, and it provides an opportunity for the products to reach a wider customer base, increase sales, and expand the reach of their products, services, or technologies. And lastly, royalty income, where they can actually generate significant royalty income, which is usually beneficial to investors, creators, and companies that hold valuable intellectual assets. Thank you very much.
Okay, thank you, Mr. Faderera. Sorry again for the way I pronounced your name if I got it wrong. So thank you for that wonderful presentation. Please, if your group members are online, please can you just show your appreciation for that wonderful presentation. He did a good job and was able to go straight to the point and hit the nail on the head. So with that, we would like to move on to the second presentation for today, group 2. If your presenter is available, can we go ahead and start? Can you go ahead and start your presentation?
Okay, good evening. Praise Chikeze Ogomachi, and I'm the presenter for group 2. We'll be dealing with the topic IP businesses, IP, intellectual property for businesses. And let me just share my screen, the documents. Okay, so I'll be sharing my screen and the document. I'm sorry.
Okay, if you are having issues sharing your screen, please can someone else in the group help her share the screen while she makes the presentation?
Okay, no, I think I'm good. I don't know if everyone can see. Okay, I don't know if everyone can see.
Yes, we can see your screen now.
Yes, we can see your screen.
Okay, so it's intellectual property for businesses. And I'll just define intellectual property briefly. Intellectual property is property involving contents or creation of the intellect or the mind. So under intellectual property, we're treating 5 basic subtopics: copyrights, industrial design, IP management, IP assessment and valuation, and lastly, trade secrets and confidential information. So we'll just quickly define copyrights. Legally, it's a concept that grants rights to a creator of an original work. Okay, and then copyright applies to a wide range of creative and intellectual works like literary works, novels, short stories, and the likes, visual arts like paintings, music, dramatic works, films, architectural designs, including software code and computer programs. Well, the main purpose of copyright protection is majorly twofold. First, to protect the creator, that's the person who creates, and protect his rights from infringement. And secondly, to incite or to encourage creativity. So when there's copyright protection of the rights of a creator, it encourages creativity. And copyright protection gives the copyright holder the exclusive rights to do 5 things. 1, the creator has exclusive right to reproduce the copyrighted work, so he only can reproduce copyrighted work. 2, the creator has exclusive right to create derivative works from his original work. In this sense, let's say he has a novel, he wrote a book, he can create a derivative movie from the book. He alone has that exclusive right. The third is the exclusive right to distribute copies of his work. The fourth is the exclusive right to perform his work publicly. And fifth, to display this work for a period of time. I hope everyone is following. Okay. Okay. The duration of copyright protection for literary, musical, and artistic works is 70 years after the author's death. So this means that copyright protection for literary works and the likes lasts as long as the author is alive, and then 70 years after his death. And then for corporate works, it's 70 years after the first publication of the corporate work. Then for such works as cinematography, films, photographs, and pictures, it lasts for 50 years after the first publication. And then we move over to industrial design. According to the IDSA, basically, industrial design is a service of creating a concept or specification, something unique about a product or a system, so as to give value to both the company, that's the manufacturer, and the user of such product or service. So industrial designs usually apply to technical and scientific products and services, such as watches, jewelry, medical equipment, and the likes. Okay, so the registration of industrial designs is very important for companies and businesses. This is because it has been provided in many treaties all over the world. The Hague Agreement, for example, and the OAPI agreements. These international treaties provide agreements for the registering of industrial designs by companies. And the benefits of registering industrial designs are in threefold. These are the important. What do we get from registering our industrial designs as a company? The first is the provision of exclusive rights. A company has the exclusive right when the company has a registered industrial design, has the exclusive right to prevent unauthorized replication of that design. So we are using the Rolex watch, for example, the particular shape and style of a Rolex watch. The Rolex company has that exclusive right to produce that sort of watch. No other company can. The second advantage is the facilitation of marketing and commercialization. But this is saying that industrial designs, like the Rolex watch, when tailored to appeal to a consumer's taste, the taste of clients, it would increase the company's assets, brand, and marketing. The third advantage is generation of revenue. So a company can license other smaller enterprises to use that specific industrial design in exchange for money, service, or other benefits. In this way, generating revenue for the company. So we'll move over to intellectual property management. So intellectual property management is important. It's like a set of methods, processes that are created to tailor a firm's particular intellectual property to that firm's particular objective and strategy. So what IP management does is that it safeguards businesses, business creations, business intellectual properties from use by outsiders without permission, and also reduces the risk of that company facing lawsuits for infringement of other companies' intellectual property. And lastly, it establishes competitive edge. So these companies have an edge over other companies because of a well-managed intellectual property. So when a business IP is properly managed, the investors are also rest assured in making quality investment decisions. I don't know if everyone is following.
Yes, yeah,
we are following.
The benefits of intellectual property management include establishment of the IP ownership and documents establishing the ownership of this intellectual property by the company. It also handles patent portfolios, infringement, piracy, and unauthorized use. This establishes non-disclosure policies. It helps the company to stay updated with competitors and their awards, infringement, and claims. It also puts together documents and prepares licensing and related contracts. Intellectual property management also enables the business to handle post-issuance proceedings in courts, and the potential for monetization can be assessed to sell and license the assets which are underutilized. Okay, so the case study is Disney. We all know Disney, a global entertainment giant. So Disney capitalizes on this intellectual property. Its companies' creations, such as Mickey Mouse and other acquired brands like Star Wars, Marvel. And so and then safeguards this intellectual property with copyright and trademarks. So what Disney does is that it, due to its very strategic IP management, it has led to substantial revenue growth and sustained growth of the company in general. That's the case study under IP management. And our next stop will be the IP assessment and valuation. So IP assessment includes a comprehensive review when a company looks at itself, looks at its intellectual properties, its strengths, its weaknesses, its trademarks, copyright, and its trade secrets. And then IP assessment helps to identify the gaps in intellectual property protection of a company, its competition, that's other companies' edge over the company, and also assesses the other company's competitive positioning. So on the other hand, IP valuation assigns a monetary value to this asset, this intellectual property, which are assets, and which are crucial for purposes such as merging, acquisition, licensing, and financial reporting. So IP valuation is crucial for transactions like merging, as I've said earlier, and litigation inclusive. So our case study under IP IP assessing and valuation is the case of Udala and Konga. These two companies were very prominent online retail firms. However, Udala and Konga decided to merge. And what happened was that Udala recognized the inherent value in Konga's name. So Konga had a strong online presence already, and Konga had a much more rich customer preference outside of Lagos. So even though Udala was the acquirer, the company that was acquiring Konga, it decided to adopt Konga's name because it recognized the value in the name. And this led to propelling Udala into the online space and expanding its offline population. So as it stands, Konga is Nigeria's largest online retail mall, and also it's the leading e-commerce and retail company in Africa. We're moving on to trade secrets and confidential information. So the UTSA, the Uniform Trade Secrets Act, defines trade secrets, I'll just quote this verbatim, as information, including a formula, a pattern, compilation, program, device, method, technique, the device, method, technique, or process that derives independent economic value from not being generally known to and not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure or use, and is subject to efforts that, under the circumstances, are reasonable to maintain its secrecy. So we're going to just go straight to the case study, which is Coca-Cola, a very popular company we all know. The Coca-Cola has a famously guarded formula for its signature soft drink, which is Coca-Cola. And this trade secret has been guarded for as far back as 2 centuries, late 19th century. And this has allowed them to maintain a unique edge in the competitive market and also prevented them from being replicated by other competitors. Up to now, no one knows the secret formula of the Coca-Cola soft drink. The benefits of trade secrets are numerous. They include competitive advantage, and these companies have an advantage over their other competitors. It still includes cost-effective protection, so they can protect their trade without such formal registration as in the case of patents and trademarks. And also it maintains the brand value, as trade secrets is a core part of the company's brand. Then flexibility, trade secrets can encompass literally anything from the process of manufacturing to customer lists. and the like. So there's the flexibility in trade secrets. Also, it avoids disclosure. Unlike patents, which requires public disclosure, trade secrets do not. So this is basically the end. Thank you so much for listening. I remain JIIPCC Praise.
Okay, thank you, Praise, for your presentation. Though there was a bit of noise in the background, but still on in all, I think we're able to get everything you said. So I would like to see reactions from your group members, appreciating your efforts. Please go ahead and appreciate our efforts. Show a sign that you appreciate what she has done, the effort she has put into the confidence level and everything. So thank you very much. Again, group 2 will be, please, you can stop sharing your screen so that we can go ahead to what's next. So we would like our mentors to comment on the 2 presentations. If possible, let's have Ms. Amela first. Please, Ma, can you comment on both presentations made by both Group 1 and Group 2, Ma?
Okay, thank you very much. I have few observations. The first observation is related to the content of the presentation, because you want to be specialized, all of you want to be specialized on intellectual property. Means that intellectual property rules, you are the first who has to follow the rules. And when I check your presentation, I observe that there is no reference to the place where you took your pictures. So as IP professional, young IP professional or IP expert, we have to respect this rule. You always have to mention the place where you took your pictures, the different pictures on the presentation. That's the first thing, except if you are the one who did the presentation, the pictures. The second thing is, I will say somehow confusion regarding the content of your presentation. Your presentation are not bad, but the content of your presentation is a mix-up of different things. Because as I mentioned at the beginning, intellectual property and business cover many aspects. So if you are doing a presentation on intellectual property and business, maybe you are doing the said presentation in school or during your defense, you have to choose a particular line. You can choose to talk about only registered and non-registered IP. It means that you want to give the definition of trademark, patent, industrial design, geographical indication, and the global view that we can have on it. But you can also choose to talk about the IP registration. Now you will be focused on the registration process in Nigeria, and after that, you can give few details regarding the process in OAPE region, the process in ARIPO, or the process when somebody wants to use, how do you call it, the international system. Okay, so if you choose either to say that you want to be focused on the contract, maybe you can just give at the beginning of your presentation an overview of the definition of intellectual property. But we can't say that we want to talk about IP and business and we mix everything into the same time. Now it means that we are talking about intellectual property globally. When I compare the 2 presentations, I think that according to the structure, we can say that the second presentation was a bit more structured than the first one, because they give the definition of, I think it was patent, not patent. They give few definitions, and after that, they were focused on the different contract, and also IP management. But it should have been more interesting to give the bullet point on which you want to be focused so that people can understand. And as I said, we cannot talk about intellectual property business without being focused in few things, because when we are focused in few things on or one aspect, it is easy for us to work deeply on this aspect. That is why you can easily in this way you can easily give advice to any person who follow you from the beginning of your description till the end, because you can say that at the end of my presentation, I asked what are the options presented to the guy, but this one is IP enforcement. But I did it like that just to show you the different aspects that cover IP and business. So I really hope that my advice are helpful, and maybe you can try to improve your content. And as I said, if you want, you can even send me back the updated version so that I can give one or two advice related to it. Thank you.
Okay, thank you, Ms. Amel. Please, can we have Ms. to presentation? Please, Ms. Regina, if you're still on the call, can you? Ms. Regina, we can.
Excuse. I just wanted to add just one thing regarding the last presentation. I've just checked the presentation. She was focused on copyright and industrial design. It means that when she works on IP management, it should have been more interesting to emphasize how to manage copyright, how to manage industrial design now. You see, how to work on valuation regarding these two different IP assets, because you will see with time, when knowing more intellectual property, you will meet that the way that you are managing maybe patent is quite different. There are a few differences if you want to manage copyright according to the different laws practiced into the different region. And at the end, she put trade secret and confidential information. Normally, trade secret and confidential information should be put at the beginning, because the beginning is somehow she's doing a general an overview. She's giving an overview of intellectual property. She just wants to present intellectual property first of all, and now she wants to enter into the main aspect of intellectual property while going on management and valuation. So I was focused on this second work because it's the one that I have in front of me, but it doesn't mean that the other parts, they didn't work well. They just have to follow up the same process. Like they go from the definition to the bullet point. Thank you.
Okay, thank you, Ms. Amel, for that observation. And please, Ms. Regina, please, can we have your contributions, ma?
Yes, thank you, Dennis. I think that Ms. Amel has said it all. The presentations were very informative. I feel that the groups actually did some research, and that they are becoming very knowledgeable in intellectual property. But I noted that on group 1 slide, I think it's page 5, where they have why a patent should be registered. I think that should have been why an invention should be registered, because if it's a patent, that means it's already granted. So why are you registering what is granted? And then I noticed that one of the group talked about patents more, patent and design, and the other talked about copyright and a few other things, but I didn't really see a bit of details in trademark, which is very important in any business endeavor. I expected that the groups should talk about trademark, at least start with that before moving on to patents and industrial design and the other aspects of intellectual property rights. And in group 2 presentation, I noted a few typographic error, and to also mention that there is need to double check generally your work before any kind of presentation, but generally it was very informative and it showed that the groups did in-depth research for this. Thank you very much to both groups 1 and 2. Thank you.
All right. Thank you very much, Mark, for your contribution. I'm sure they will do well to make necessary adjustments. And finally, can we have Miss Christiana? Thank you, Ma. We would like to have your contributions on the presentation, Ma.
All right, thank you very much. Ms. Stella and Ms. Regina has already, they've said most of the things, but what I noticed is that I think from group 1, they talked about more on patents and trademarks. I don't know if that was how it was being designed. They talked more about patents and trademark, while group 2 talked about industrial design and copyright. I don't know if that was how it was being designed, but I just noticed that when you look at the both presentations, they complement each other very well. So, I just think the both presentations, they complement each other, and just like Ms. Regina has said, you have to talk about trademark first before talking about patents. Though if you look at it too, for example, now if you have a technology product, you need to be granted a patent first before you would be granted, before you'll be able to register the trademark. Maybe they are looking at it from that angle, but most times the real IP intellectual property for businesses, we talk about trademark, and that's just the major topic there. Yeah, so I think overall it's a good topic. It was a good presentation, and the both of the presentations, they complement each other. Thank you. I'm so sorry for the background noise on that.
Thank you very much, Ma. I think the issue that was there was the fact that the presentations were made under different subheadings as what we gave them to present on and research on. We gave them different subheadings tied to intellectual property for business. So I think that's where the disparity is in. But that being said, I'm sure some people on the group have questions that they would like to ask our mentors. Some from the case study Ms. Amela put up. If there are questions, you can direct it to the mentors here. You can raise your hand, or you can send the questions to the chat box so that whatever questions you have can be addressed. So are there questions? Okay, I can see someone raising his hand. Mr. Popola Ahmed, please, you can go ahead and unmute yourself and ask your question.
Yeah, so good afternoon. Thank you for all the knowledge that you've impacted on us. So I wanted to ask one question. Under patents, there's a type of patent called designs, and there's also industrial design. So I wanted to ask that, are they the same thing, or they are different concepts totally?
Okay, regarding your questions, it depends on the region where you are, because here in Cameroon, in OAP region, I mean, we just have patent and design. That's all. So we don't have patent design. But in few regions, like in China, we have what we call patent design. Okay, and patent design is another way to protect design. So to answer to your question, it really depends on the region where you are working on. I don't know specifically, I didn't have time to make some search regarding Nigeria, if you have patent design, but maybe the others one can tell us if you have patent design in Nigeria.
Miss Regina had talked about it during her presentation. Maybe she can just expatiate more on it. She addressed it.
So I talked about patents and industrial design. So, but I think that the question is if there's a difference between patent design and design patents, right?
Yes, because
No.
in China, you can
Excuse me.
protect design with patent design. But is it the same in Nigeria? That's my question.
No, it's not the same. So in Nigeria, you either protect your patents or you protect your industrial design.
Okay, so it's the same as in OAP region.
Yes.
Okay, thank you.
But I think that what most people refer to as design patents is industrial design, and they just prefer to call it design patents. By and large, it's still design industry. It's either industrial design or patents.
Yes, it is industrial design, but it is protected. It is possible to protect it as patent design. But the different criteria that they use to protect it, honestly, I don't have it all. But I know that it exists in China. Because I started working on the protection of a design in China with one client from Belgium, and this is the feedback that they gave me. But since I didn't finish the registration, we didn't finish the registration, so I don't have a complete response, but I know that it is what we call here design, that they also call patent design into the region, but I suppose that there is a particular way to protect it. So I don't know the different criteria to protect it.
Okay, thank you very much, Mars, for answering that question. I think I can see Mariam Abubakar's hand up. Please, can you go ahead and ask your question? Then we'll take the questions on the chat box.
Okay, so my question is, during like our research, like when, for example, now let's say I'm researching on like a case study for intellectual property management, how a company manage their IP properly and what they gain the revenue. So like how should we like find these case studies? Like what method should we use like in order to easily like access these case studies so that we can add them to our research?
Yes, I've seen that question. Here in OAP region, we have particular database, but the main challenge for those who come from English region is that OAP region, we work in English and French just for application, but all the other things are written in French. So if I share the document with the person, it's true that that person also have to see how to translate it. And since it is not into a Word format, somehow it's challenging, but we have. And you can also have it in European Patent Office, and even WIPO also have few database like that. So maybe you can get back to me in order to give you few links. No problem.
Okay.
Just to add to that, I think that you can also do like some internships in a law firm. I think that's also going to be beneficial. And then also internships in maybe the trademark registry, that's if they allow that as well. And you can be like a research assistant to, since you know yet, if you're not practicing yet, you can be a research assistant to a lawyer that is specialized in this field as well. So you'll be able to, get resources and get more insights.
Okay.
Just to add that Google is your friend.
Yes, Google is your friend.
Okay, thank you so much, Miss Christina and Miss Amel. Miss Amel, okay, I appreciate it if you can send the link. Yeah, thank you.
All right. Thank you for your questions, and thank you, mentors, for the answers you gave. I think we should be going to the questions on the chat box. Let me read them out, and our mentors can go ahead and address them. The first question is, how do we monetize IP, especially for engineering designs and processes?
Okay. Regarding IP monetization, what I can say is that everything depends on what the client is looking for. It's not depending mainly on the type of the IP asset, because you can do IP monetization with copyright, you can also do it with patent and any other IP asset. But you have to know that the thing is depend on the business model of the company. Let's take an example. During our conversation, we mentioned, I don't know if it was McDonald's, who sell food. In this case, the company wants to develop the same business model, the way that they are selling food. They want to use the same way in different countries over the world. You see that here we are not sharing only the logo, we are sharing the practice. Okay, we are sharing a business model of a company with other people. So in this case, you can have franchising. But if somebody has his own company, like let's take another example. With my own example, I have Cabinetier and F, and now there is somebody who said that he wants to use the same brand in another country. Let's take the example of Losoto. If he wants to use the same brand in Losoto, since my brand is already registered in OAPI, we have to check if my brand is also registered in Losoto, so that in our agreement, I will mention that I give him a license to use my brand. And according to that, the guy will give me something maybe at the end of the year or each month. Everything depends on the agreement that we have. So we have different types of IP commercialization, but it's really depend on the objective and the vision of the company. So after doing what we call an also IP consultancy, the IP attorney is more able to understand what are the needs of the company, and according to that, he can advise the client to go in one option or another one.
And this is Regina to also add that it largely depends on the IP strategy. Ms. Amel had alluded to that, and the nature of the IP involved. So if, for instance, an inventor invents or creates a model to produce a car, you will not primarily be looking at franchising. And we understand that the primary objective of an inventor is to, aside the utility purpose, is to make money. So if you're inventing and there's no financial benefit from your invention, the inventor is not encouraged to continue to research. So you either look at licensing or assignments, which is what most businesses or inventors do to approach those who have been in the field, the big fishes, the big companies, to either license that intellectual property rights, which could be the patent or trademark or the industrial design, as the case may be, or to assign the IP rights completely with the aim of getting the monetary benefits.
All right. Thank you, our mentors, for answering our questions. Let's go to more questions on the chat box. So there's a question from Victoria. Okay, sorry. From Victoria, how are trade secrets and confidential information protected? And someone had, in addition to that question, is trade dress also protected and registered?
Okay. Regarding the first question, trade secret and is what? The question is the difference between trade secret and what, please?
How are trade secrets and confidential information protected?
Okay, so trade secret is any confidential information that is important for the company, for which the company took few steps in order to ensure that somebody cannot misuse it. So the value of trade secrets comes from the way that you protect your confidential information. But this type of intellectual property are not registrable. You just have to do what we call in intellectual property a notary act. It means that if it is, for example, a concept that we want to protect, not a concept. If you have a trade secret related to maybe your how can I call it, the formula of any product. Okay, you wrote your formula somewhere into a particular book, and now you ensure that people will not have access to it. Maybe you put the said formula into a closed place where there is only two persons who has access. This is the steps that you choose to put in place in order to secure it. So after that, you choose then to go and meet an attorney, a notary, in order to save it here. The action to save is to ensure that if maybe there is somebody who succeeds to have access to the information, unfortunately, that you can prove that you give this to the notary and the guy put a particular date in order to ensure that your trade secret can have a date. Because at the end of the course, when we have a certificate for trademark, for patent, it's just to have a date that proves that we are the one who filed it in front of either OAPE, Office of Nigeria, Office of Intellectual Property, ARIPO, and so on. So it is a similar action that we will do in front of a notary. Since here we don't have things like to send the document by emails to your own person in order to ensure that you did it in one day at a specific time. In fact, in OAPE region, is something that is not receivable. But in some countries in Europe, you can do it and they will take it as a proof of your confidential information that you put on a sheet of paper. So that is my contribution for this question.
I also think that they can also be protected via non-disclosure agreements, just like Ms. Tala have said that they are not registrable. So you're just bound by the agreements that you've signed. That's all.
Right. Thank you very much for that answers, Mars. I think there are a few other questions that were asked by the group after they did their made their assignments, like the they compiled their presentation and submitted. Some of the questions here are, first one is, are there specific industries or business models where intellectual property plays a particular critical role, and how do they navigate IP challenges unique for their sector?
I've been thinking about this question, and I don't know. I'm still trying to think about the the business that you would do, and you don't need you don't need to protect your intellectual property. I'm still trying to think, but I've not still been able to talk about it. But just tell you that there's no business you do that you don't need some aspect of intellectual property. But basically, for maybe you're trying to talk about what area of what kind of business will you do that you will need this particular kind of IP. That's what you're talking about. For example, for pharmaceuticals, for technology, you need to be granted patent to be able to move forward with whatever you're doing. And then for like normal businesses we do, if the business has a name, you need to trademark the name for it to be protected. So I don't think there's any business you do that you don't need some form of intellectual property needs. And it's possible you even need more than one intellectual property. For example, if you have like a technology product or a pharmaceutical product that you invented and you've been granted patents, then after you've been granted patents, you need to also trademark the name as well. So there's the first answer there is that I don't think there's any business you do that you don't need some form of IP. And then the second thing there is that it's possible you even need more than one IP to be fully protected in whatever business you're doing. Thank you.
Okay, thank you very much, Ma, for that answer. Second question is, can you explain the different types of intellectual properties, such as patents, trademarks, copyrights, and trade secrets, and their respective roles in protecting creative works, and innovations?
I think that we have already responded to this one.
Okay. Yes,
Yeah.
yes. Okay. How do businesses go about obtaining and maintaining patents, trademarks, copyrights, and what are the associated costs and timelines?
Okay, so regarding, I just want to underline regarding the first question that the answer was the right one, because you can see that there are particular IP assets that are used in particular business. But regarding IP strategy or business model that you have to use, it just depends on the targets of the company. But following this question, your question is about obtaining and maintaining. I think that we work on obtaining. We know that there are some IP assets that are registrable and other ones that are not registrable. That is the basic thing. And you already know the difference. The ones that are registrable are trademark, patent, and industrial design, and so on. And the ones that are not registrable, for example, trade secret. Okay, but how to maintain these different rights? To maintain them, there are some that you just have to renew, like patents. Patent, you have to pay fees after each year in order to ensure that they will stay alive during the 20 years, because patent lasts for 20 years. But for trademark, you have to renew it before the end of before the beginning of the 10th years, because it lasts for 10 years. So at the end of the last year, the 9th year, you always have to remind that you have to renew it in order to have it during the whole life, let's say that. For copyright, we also mentioned it during our presentation. And the ones that are not registrable, simple as the time that you are still able to keep it secret, you can save your trade secret. That is why I mentioned it at the beginning of the discussion. For those who think that trade secret is right, it is not a good point of view, because the challenge here is to ensure that you can save the information secret. But it doesn't mean that
it is less important or less strong than patent, for example. So you just have to ensure, according to the option that you took, either you are taking one or you want to combine many options to ensure that you have the resource, financial resource and human resource that will help you to secure and to maintain your right.
All right, Ma, thank you very much for that answer. Thank you very much. I think the last question has been asked by Miriam, so I don't think there's any need to go to ask that question again. So are there more questions? Any other questions that the mentees would like to ask before we close the session? Okay, if there are no others.
I think I saw a question where someone asked, where can the trademark patent be registered? Yes, so to answer that question, it can be registered in the Federal Ministry of Trade and Investments.
What is the question, please?
I saw a question where someone asks, where can patent trademark be registered? So in Nigeria, it can be registered in the Federal Ministry of Trade and Investment. I don't know about other part of Africa.
In OAPE, you just have, I just want to underline one point before we leave, is that OAPE region covers 17 countries. So any application that you do in OAPE region can be enforceable into the 17 countries. So you don't have to pay fees for each of the 17 countries. It's somehow like you are doing an international registration of a trademark. So the fees that, the official fees that you have to pay cover either Cameroon, Niger, Senegal, Ivory Coast, and so on, all the 17 countries. And even if you have a litigation, you can enforce it and the decision will cover all the 17 countries. So OAPE is based here, and we have few branch into the different countries, but the branch is just there. It's not like OAPE branches. It's somehow the representative of OAPE who can help you to send your application to OAPE if you cannot send it directly, or if you don't have an IP counsel, let's say that. And last point is the one regarding our case study. I mentioned the point, what was the option that was having the guy into our case study. I think that the name that I gave was Ariel. The option that he was having is to make what we call a claim of ownership. We have to know that when somebody works with someone, or when somebody is into the collaboration with somebody, and that person knows that he has IP rights, and the said IP rights are not registered yet, he doesn't have the right to go behind and register it, because we can prove that it is a bad faith. Also, in this case, if the guy can prove that he were collaborating with this other guy, now it is easy for him to go at OAPE, apply now for registration of his own trademark, and enforce the right while proceeding to what we call claim of ownership, in order to demonstrate to OAPE that the guy was having a bad faith. So I think that I've covered all the aspects of my case study. Thank you.
Thank you very much, Ms. Amel. I think there's still one question here. Can IP protection rights be transferred from one company/organization to another?
Yes, it's possible to do that. A transfer, I think that what you call transfer is, how do you call it? You want to sell IP rights. Praise? Okay, yes, it's possible, because through the transaction of intellectual property, it's possible to license partially and it's also possible to sell your intellectual property. There are many companies at a particular time who often choose to sell intellectual property, maybe because they feel that the said intellectual property is no more interesting for them. For example, pharmaceutical company, maybe they can have a particular patent that they were using during the COVID-19. And now, since COVID-19 is no more something that is really grave, they see that they no more have enough money with this patent. Either continuing to pay to maintain the right, they can choose to sell it to another company. So this one is the decision that they can take through IP strategy or management of their portfolio.
Yes. Sorry, can you hear me? Can you all hear me?
Yes.
Okay, I think someone is asking if question 4 can be re-answered. The person made mention, that is Abimbola, said she didn't get the first time the question was answered.
Which question? The last one?
Yeah, the last one, the one on case studies, how to properly find case studies when to use when writing and making research on topics related to intellectual properties.
Excuse me, how to? The line was breaking.
Okay, how to properly find case studies to use when writing and making research on topics related to intellectual property.
Okay, I told her that I sent my email in order for those who are interested by that to just email me and I can send you a few links.
All right, thank you very much, Ma, for that. Thank you for all your support and help. Okay, I think with that, we've come to the end of today's class, today's section, IP for business. We want to thank our mentors, Miss Amel, Miss Regina, and Miss Christina, for how much effort they put into the session and their contributions on the topic. We want to thank you for making out time out of your busy schedules to help enlighten us on this particular subject matter. We look forward to also hearing from you in the future and also getting to learn from you more in the future. Thank you for your time. Thank you for your efforts. JIIPCC says thank you. With that, we've come to the end of today's section. I think it's already evening here. I don't know where everyone else may be right now, but with that, I can say good night, everyone. Please do all have a wonderful night rest. Thank you.
Thank you, Dennis. Bye. Thank you all.
Yeah, all right. Thank you. Goodbye.
Bye.